All right, welcome back. This week we are going to talk about civil rights and chapter 5 of your OpenStax textbook. Remember last lecture we distinguished the difference between civil rights and civil liberties, and we delved into what civil liberties were and the Bill of Rights and how those protections, constitutional protections, were put in place. So now we're going to discuss civil rights and kind of go through the various movements of different oppressed groups and kind of see how civil rights has evolved. So before we started, I wanted to share this quote from your book. This is an example of how to do an in-text citation as well. As you should know, you can see the in-text citation that I did here with from the OpenStax textbook. But this really summarizes thoughts on civil rights, and it is the belief that people should be treated equally under the law is one of the cornerstones of political thought. So that's really the driving force behind civil rights and various civil rights movements. If you will remember back to our opening lecture and our opening lecture toward the the Constitution and its origins. We talked about the preamble, which is "We the People," and so throughout political history, "We the People" has taken on various forms because there are those who believe that not everyone has been blessed to have protections under the Constitution, and that's where the civil rights discussion comes in. So we're going to go through this one more time. Civil liberties and civil rights are distinct concepts, and they are different. So remember, civil liberties are the limitations of government power designed to protect freedoms, whereas civil rights are constitutional guarantees that the government and all government officials will treat people equally regardless of whether they belong to a protected class, such as race, gender, ethnic origin, and religion. So civil liberties is talking about the limitations of government power on protected freedoms, whereas civil rights is really kind of talking about putting those constitutional guarantees of equality into action. So you can't talk about civil rights without talking about the Equal Protection Clause of the 14th Amendment, which was ratified in 1868, and it states that no state shall deny any person within its jurisdiction the equal protection of laws. So it's important to note that the Supreme Court interpretation of the Equal Protection Clause is that all persons similarly circumstanced shall be treated alike. This is more commonly restated as similarly situated individuals are treated similarly. So that's your Equal Protection Clause, and it's really the basis of our civil rights discussion under the 14th Amendment. All right, so before we move on to talk more about the Equal Protection Clause and equal protections and civil rights movements, it's important that we understand the term discrimination. After all, this chapter is rooted in discriminatory practices and people of varying classes and varying subgroups fighting for equality from discrimination. So when we're talking about discrimination, we're talking about treating people differently on the basis of race, age, sex, sexual orientation, things like that. And it's important to note that discriminatory laws do infringe on civil rights, or those rights that we believe that all people should have. There are times where laws are determined to be discriminatory, and those type of laws, that impact of those laws basically treat people differently. So remember, in the last slide, we talked about how we're looking at people in similar situations being treated similarly. Well, here with an undertone in discrimination is people in similar situations being treated unequally or being discriminated against. All right? So that's important to kind of understand as we go forward. All right, so let's talk about equal protection in the courts. All right, so let's look at how the courts look at equal protection. So when a law discriminates, the courts look at the purpose of the practice in deciding whether the law is constitutional. And they apply different levels of scrutiny to this process. Laws involving discrimination against protected classes receive the highest level of scrutiny and are thus found unconstitutional oftentimes. So let's take a look at these levels of scrutiny that the court utilizes. There are 3 levels of scrutiny. You have, and let me get the handy dandy highlighter. You have the rational bias test. You have the intermediate scrutiny and strict scrutiny. Okay? So we're going to take these one by one, and this was the best visual aid that I found that really kind of helps you see it side by side. You do have a copy of this in your publisher PowerPoint, so you will be able to spend some time on this on your own. So let's start with the rational bias test. So the rational bias test basically states that the law is rationally related to a legitimate governmental interest. This standard is used by the courts to decide most forms of discrimination. The burden of proof is on those challenging the law or action to demonstrate that there is no good reason for treating them differently than other citizens. So basically with the rational bias test, it is on the person stating that they are being discriminated against to show that there's not a governmental interest in the law, and that they have to demonstrate that there's no good reason for treating them differently than other people. Okay, let's move on to intermediate scrutiny. This is substantially related to an important governmental objective. So this intermediate scrutiny, this is something I want you to make sure you understand. Intermediate scrutiny is used when we're talking about gender and sex discrimination in cases. All right? Intermediate scrutiny is used in gender and sex discrimination cases. The burden of proof is on the government to demonstrate that the governmental interests at stake, that there is an important governmental interest at stake. But the most important thing that you should take away from this is intermediate scrutiny is used with gender and sex discrimination. All right? Strict scrutiny is the third level of scrutiny used, and it's basically stating that there's a compelling governmental interest, it's narrowly tailored, and in the least restrictive means. So this is the standard that is utilized when, let me get my handy dandy highlighter, when determining cases of discrimination based on race, based on race, ethnicity, national origin, or religion. So if you're talking about discrimination based on gender or sex, the court usually uses intermediate scrutiny. But if you're looking at cases involving race, ethnicity, national origin, or religion, they typically look at strict scrutiny. And with strict scrutiny, the burden of proof is on the government to demonstrate a compelling governmental interest is at stake, and no alternative means are available to help them accomplish that goal. All right. There's a lot more detail that goes into these levels of scrutiny. For an introductory class, this is basically your high-level overview of the different types of scrutiny that you should kind of know. And I've highlighted probably what you really need to know about them. Whereas intermediate scrutiny is utilized in gender and sex discrimination cases, and strict scrutiny is for race, ethnicity, national origin, and religion. Okay? All right, so let's dive into some of the historical perspectives of civil rights. You cannot talk about civil rights without talking about, first, African Americans and their struggle throughout the history of the United States. And we can't start without talking about slavery. Slavery has been a huge issue throughout the U.S. history, including one of the founding fathers, Jefferson. He owned slaves. He did later renounce slavery, but he owned slaves. There is a foundational Supreme Court case that kind of put slavery into perspective in the early years. And that was the Dred Scott case, Dred Scott v. Sanford in 1857, where the court denied freedom to an enslaved person, basically stating African Americans could not become free because they were not considered citizens. Just think about that. That's the mentality that our nation was founded on. Was African American slaves were not considered citizens. Remember, go back to the 3/5 Compromise, where states were trying to make a play that our slaves should be counted in our total population, but then you turn around and the court, in one of the earliest cases, says slaves can't be free. They're property. They're not considered citizens. Dred Scott also prohibited the government from passing any laws limiting slavery. So again, the federal government could not pass laws that limited slavery in states during Dred Scott. So this was in 1857. The next big thing happened in 1863, and that was when President Lincoln signed the Emancipation Proclamation. So we know that there was a battle between should slavery exist in the U.S., should it not? President Lincoln was the first president to basically take a stand and say, no, we're going to emancipate slaves and make sure that they are not thought of as property. We want them to be free citizens. So with the signing of the Emancipation Proclamation, he held that all persons held as slaves henceforward shall be free. Now, do you think that every slave, as of January 1st, 1863, was truly set free? No. The answer is no. The Emancipation Proclamation really was limited to only the states that rebelled against the Union. Therefore, not all slaves were truly set free. It was a good first step, but it was not a comprehensive step because, again, remember, state powers, federal powers. Although we have the supremacy clause, you still have a couple of years before you truly kind of see everybody being set free. That led into the Reconstruction era and what are known as the Reconstruction Amendments to the Constitution. So when we talk about Reconstruction, that refers to the post-Civil War period between 1865 and 1877. During this time, governments of the Confederate States are reorganizing, and they had to, as part of that reorganization, they had to make it known that they would not hold slaves before being readmitted into the Union. The Reconstruction Amendments were intended to prevent slaves from enacting what were known as black code laws that deprived former slaves of their rights and liberties. And it's important to note that the Reconstruction Amendments were the 13th, 14th, and 15th Amendment. So the 13th, 14th, and 15th Amendment. Let me pull my notes real quick. So we know the 13th Amendment was the amendment that freed the slaves. The 14th Amendment was the amendment that prescribed civil liberties to slaves. And then the 15th Amendment was the amendment that allowed African American males the right to vote. So taken together, the 13th, 14th, and 15th Amendment were known as the Reconstruction Amendments. So let's look at them a little bit. So the 13th Amendment says, neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist in the United States or any place subject to their jurisdiction. The 13th Amendment ended a long-standing conflict between slaveholding and non-slaveholding states by abolishing and prohibiting slavery and involuntary servitude across the United States. So you have the Emancipation Proclamation, in which Lincoln signed in 1863, that was intended to free slaves. However, slavery was not fully abolished until the 13th Amendment. It's important to note. Then you have the 14th Amendment. The 14th Amendment says, all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive a person of life, liberty, or property without the due process of law, nor deny any person within its jurisdiction the equal protection of laws. So the 14th Amendment basically ensured that national and state citizenships of former slaves were established, and it prevented the states from discriminating against citizens of other states, implied a right to travel amongst the states, extended due process requirements to the states, and promised equal protection under the law. The 14th Amendment was huge. All right, so as well-intended as the 14th Amendment was, and as well thought as it should have been, it did not really limit discriminatory practices against African Americans, especially in the South. So during this time, you have have what are called Jim Crow laws. And those are laws that were passed with the intent to disenfranchise black voters. And we'll talk about disenfranchisement here in a little bit. But basically during this time, this is where you see separate facilities being used, like black only bathrooms and white only bathrooms. You see different water fountains having to be utilized, different schools. Segregation is what we call that. You still see segregation happening in the South, especially. So in 1896, in the case of Plessy v. Ferguson, the Supreme Court took up the matter of segregation, and was segregation constitutional? They upheld what we call the separate but equal doctrine, and basically that doctrine states as long as as nominally equal facilities were provided for both races, it was legal to require members of each race to use the facilities designated for them. Bam! With that one case, the precedent set was that segregation was okay. Well, as you can tell, this did not set well with those being discriminated against. And so the NAACP in 1920 began to push to overturn these Jim Crow era laws and try to undo disenfranchisement. So let's talk a little bit about disenfranchisement. All right, so disenfranchisement was the practice of making it as hard as possible for African Americans to pretty much vote. And there were certain practices that were put in place, especially in the South, where segregation was still ongoing, and the powers that be did not want African Americans to exercise their 14th Amendment rights. So, although the 14th Amendment said that they basically gave the civil liberties to African Americans, the South especially found some loopholes to further discriminate against African Americans. There are different forms of disenfranchisement. The ones that we're going to talk about right now are especially for voting. And so the first one is literacy test. So if we were in a face-to-face classroom, I would have started this conversation by giving you a quiz when you walked in. And the quiz, you would have looked at me and you would have panic in your eyes, because you would have been like, oh, what is this? We haven't covered this. Well, that quiz would have been the actual literacy test that was given at the time that segregation and disenfranchisement was happening. Literacy tests were tests that required the prospective voter to read a passage of a text and answer questions about it. So while we look at it like, well, what's the big deal? Remember, back in this time, African Americans did not have the educational opportunities. Even some whites didn't have the educational opportunities, but they were grandfathered from literacy tests. Then again, you also have the fact that, could you imagine going to vote and having to take a test just to get a voting card to vote? Like, what is that? But that was a common practice back in the Jim Crow era. Then you have another type of test, which is called the understanding test. These tests included, they had to read passages and explain them or answer questions about citizenship or U.S. history. There were a lot of citizenship tests that had a lot of very nuanced information that I don't know that you could probably pass. Then we had what were called poll taxes. And poll taxes were very common. And this was basically people paid a tax in order to vote. And then, of course, they had white-only primaries, which excluded minority voters from participating. Basically, only white people could participate in the primaries. And when we talk about primaries, we haven't covered primaries yet. We'll talk about that during when we talk about voting. But primaries are your initial steps in the voting process, where you might have multiple candidates running for one office, and the voters choose among those candidates which one is going to advance to general elections. So back in this time, they had primaries, but only whites could vote in those primaries. Here is a picture from your text that I wanted to include. This is a receipt of someone who paid $1 in poll taxes to vote in Jefferson, Louisiana. So just kind of puts it into perspective that poll taxes were real, and here's a receipt to show. All right. So after World War II, the most famous examples of segregation, which is segregated schools, separate accommodations on public transit, the exclusion of persons of color from commercial establishments, were the first areas targeted by what was known as civil disobedience and direct action campaigns during the civil rights movement. So remember, with Plessy v. Ferguson, the Supreme Court laid the precedent down that said, absolutely, as long as we give nominally similar establishments between the two races, segregation can happen. Well, now after World War II, we start seeing what we call civil disobedience, which is like your protesting, things like that. That starts happening because people are realizing that Jim Crow and the Jim Crow era of laws and segregation is not really tolerable anymore. So civil rights campaigners often face tough and sometimes violent local and law enforcement oppositions. I'll show you a picture here a little bit about rioting and a march across a bridge in Selma, and which is a famous march. You see a lot of different law enforcement brutality during this era. Civil disobedience, protests, and the civil rights campaigns to integrate schools and register black voters in the South brought forth change from the Supreme Court and legislatures. So remember, we have Plessy back in 1896. Now we're going to have a historic decision from the Supreme Court. This is one that you probably should highlight, write down. I'm going to highlight it on here. Brown v. Board of Education. Basically, in Brown v. Board of Education, this one case overturned segregation and integrated African Americans and white people. The court overturned Plessy. They saw that they erred in their ways, and so they made it right and ended segregation with Brown v. Board of Education. Here are some of those pictures of some of those civil disobedience and marches and things like that. You're going to see in A, Police attack on civil rights demonstrators as they cross the Edmund Pettus Bridge on their way from Selma to Montgomery. This was known as Bloody Sunday. And then you see here that the recently departed John Lewis's funeral procession crossed the Edmund Pettus Bridge. The Edmund Pettus Bridge is a historical landmark in civil rights history, and so Representative John Lewis's funeral wanted to make sure that they marched over that because he was there at the original march as well. All right, here's another picture that's a truly historical picture. This is a picture of soldiers who had to have been called in Little Rock, Arkansas. These are students, the first students to be integrated into an all-white high school. And it's important to note for years, soldiers had to escort 9 African American students to and from school and to and from classes within the school just because of all the opposition. So just because Brown v. Board of Education passed did not make it easy for integration to happen. So as we will see when we talk about the Supreme Court, and as you can see now in the political climate that we live in, just because the Supreme Court changes a stance or what we call precedent, just because they set a new precedent does not mean that it automatically everyone will accept it and that precedent won't change in the future. An example of that is Roe v. Wade and the Dobbs decision, which we'll talk about. So with Roe v. Wade, abortion was legalized, and then it was never codified, which means put into a legislative act or code or legislation. So the Supreme Court could come back and overturn their precedent in Roe in the Dobbs case. So if a precedent is set only by a Supreme Court decision, while we understand that that's the way it should be going forward, there's nothing that says that the Supreme Court can't overturn their decisions, and thus you lose those rights. The only way that you lose those, that you can ensure that those rights are kept and the court can't just backtrack like it did with Roe, is to codify it in legislation. Or codify means to write it in code. So we see that there was a Civil Rights Act of 1964, and that act outlawed government discrimination and the unequal application of voting qualifications by race. So here you see the Brown v. Board of Education decision really kind of being codified into law. And the Civil Rights Act further outlawed segregation and other forms of discrimination, and it prohibited discrimination based on the basis of race, ethnicity, religion, sex, and national origin by employers. And this is an important concept. It created the Equal Employment Opportunity Commission to enforce the law. The EEOC is still going today, and they investigate charges of discrimination in the workplace. So the Civil Rights Act of 1964 really put it into law, put Brown v. Board of Education into law, and made it illegal for government or any entity to discriminate based on the basis of race, sex, religion, ethnicity, things like that. The question I ask you to just ponder is, Did the Civil Rights Act end discrimination as we know it? I say no. We still struggle with the concept of equality today, in today's time. We still struggle with discrimination today. And one example is in the criminal justice system. We have just gone through the past, 3 years of turmoil and upheaval in our criminal justice system to bring out what is called inherent racism or underlying racism in the system itself. You have seen that through George Floyd, Ahmaud Arbery, Breonna Taylor, the Black Lives Matter movement, things like that. However, there is extensive research in the criminal justice realm to also show that there's a lot of inequality in our incarceration practices. So what I mean by that is people going to jail. There is proven statistical research that shows that there is inequality in who goes to jail and who doesn't, or who spends the time. Just some little known facts. These are not going to be on the test. I don't believe I put these on the test. But the U.S. incarceration rate has gone up 500% over the past few decades. There's a lot of reasons for that. The war on drugs from the 80s plays a major factor in that. And the war on drugs itself can be said to have racist undertones because it targeted minority populations and minority communities to round up those drug uses. More than 7 million people have gone to jail or prison. Just let that sit with you for a minute. More than 7 million people have gone to jail. The most staggering statistic that has come out of the study of inequality in our criminal justice system is this: 1 in 3 black men will go to prison during their lifetime. 1 in 3 black men will go to prison in their lifetime. So if you line up a classroom of 25 students and count off by threes, every third student will have gone to jail, according to this statistic, if they were black. It's kind of a staggering statistic. All right, so let's move our focus now. African Americans, while they make up the majority of what we think about civil rights, they are not the only minority group that has struggled for civil rights over the history of the United States. Now we're going to turn to the women's suffrage movement. So remember when I talked about the 15th Amendment giving black men the right to vote? I made very clear that they were men, because women did not have the right to vote for much of American history. And when we talk about suffrage, we're talking about the right to vote. Okay? So the movement for women's suffrage began campaigning in the mid-1840s for women's right to vote. Some Western municipalities, territories, and states allowed women to vote in local elections, but women's right to participate in elections only came after the ratification of the 19th Amendment in 1920. All right? So 2 things you need to remember here. The 19th Amendment is what gave women the right to vote. And I'm doing a terrible job drawing on this, sorry. The 19th Amendment gave women the right to vote. Women did not, that amendment, the 19th Amendment, did not pass until when? 1920. Women did not have a protected right to vote until 1920 in the United States. Despite stating that the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on the account of sex, the 19th Amendment largely extended the vote to white women until the 1960s because of minority disenfranchisement rules. So women gained 1920 the right to vote, but the Jim Crow era, the disenfranchisement laws, all of that kind of held back non-white women. Here is a picture of a suffrage march down Fifth Avenue in New York demanding the right to vote. So just like any other minority group, the women took to the streets and had some civil disobedience themselves. Does this sound familiar when we talked about how people can engage in the political system in week one? One of those was protesting and peaceful protesting and bringing the knowledge to the general public, and they did that through street protest. We still do that today. So here are two pioneers in the women's suffrage movement that your book covers and that you really should pay close attention to. So Elizabeth Stanton and Lucretia Mott were two women who got really perturbed that they were not allowed to go into a meeting to discuss voting rights. So what did they do? They made their own meeting called the Seneca Falls Convention, where they got everybody together to discuss the suffrage movement and basically launch the suffrage movement. During the Seneca Falls Convention, they wrote what would be known as the Declaration of Sentiments. This declaration proclaimed that women deserve the same right as men, and thus you launched the women's suffrage movement. So if you see something that says, who were the pioneers of the women's suffrage movement, you know that that's probably going to be Elizabeth Stanton and Lucretia Mott. Or how did the women's suffrage movement launch? The Seneca Falls Convention and the Declaration of Sentiments. All right? Before we move on to our next group, do we still see women trying to gain the same rights as men in today's society? Yes, we do. I bring to you the fact that really within the past, 2 years? Well, 3 years, because we'll be in 2023 when you watch this. We've just now had a woman vice president. There still is what are called glass ceilings left to shatter, especially in politics. But we still see there's pay discrimination. Men make more money than women. You see that there's some like Kamala Harris who are trying to break down those walls. Hillary Clinton tried to break down walls by being the first woman to run and serve as the president of the United States. And I think largely our society was not ready for that. We just saw the first black president with President Barack Obama. So women are still trying to gain equality even in today's society. All right, so let's talk about indigenous groups, which are the Native Americans, Alaskans, and Hawaiians. Native Americans were forcibly removed from the eastern United States along the Trail of Tears from 1831 to 1838 through what was known as the Indian Removal Act. Over the next century, as the U.S. expanded westward, Native American groups increasingly lost their lands and sovereignty while simultaneously being excluded from U.S. citizenship. The Indian Citizenship Act of 1924 granted citizenship to all Native Americans born after its passage. It was not retroactive. Older Native Americans who had not secured citizenship through military service became citizens under the Nationality Act of 1940. So, if you were born before the Indian Citizenship Act took place, you did not get citizenship if you were a Native American until 1940. 1940. After naturalization, Native Americans faced the same segregation and disenfranchisement laws as African Americans. The U.S. courts repeatedly declined to extend many constitutional liberties and rights to reservations, which are kind of quasi-autonomous nations whose lands are held in trust by the U.S. government through the Fifth Amendment. The Indian Civil Rights Act of 1968 extended to reservations many of the civil liberties and rights granted under the Bill of Rights. And then in 1973, the American Indian Movement occupied Wounded Knee, South Dakota, demanding the federal government honor past treaties in which it failed to perform its obligation. The 71-day standoff with federal law enforcement killed 2 people and injured 15. So you can see, even going back to our nation's founding, that Native Americans were truly one of the first class of people discriminated against. This is important. After the passage of the Indian Removal Act, the U.S. military forced the removal of the Cherokee, Chickasaw, Choctaw, Creek, and Seminole from the southeast to the western territories, marching them on routes shown here. The lines in yellow mark the route taken by the Cherokee and the Trail of Tears. So I live in Chatsworth, which is North Georgia, and the Trail of Tears runs through Chatsworth. The Trail of Tears runs through much of northwest Georgia. So if you have not been able to see any Trail of Tears historic sites, they're in your backyard. So here is just some of the visual aids where you can see for Wounded Knee. This is the marker for those who died at Wounded Knee, and then here's a bullet-riddled car from that standoff. So let's talk about some of the other significant civil rights movements. Um, Most Asian Americans were excluded from citizenship and naturalization in the U.S. until the 1940s. During World War II, Japanese and Japanese American individuals were ordered to internment camps. So during World War II, we basically segregated Japanese and Japanese Americans in these camps, what are called internment camps, where they could not leave, and I'll show you a picture here in a minute. It's very sad. Latino and Chicano groups advocated for rights for immigrant farm workers and pathways to nationalization for undocumented workers. They fought against employment and education discrimination. This fight is still ongoing today. Immigration is one of the hottest topics in the U.S. political system and policy stance. We see that our border is a hot topic, and people have varying opinions on what should happen at the border. So we see that this group is still highly discriminated against. Here's a picture of a Japanese internment camp. So you see these people are standing in line to get to what was known as the mess hall or the kitchen in California. The last group that I want to talk about are the LGBTQ plus group. And I want to put some things into perspective for you with this group and kind of just let you make your own assumptions. So this is a picture of supporters of marriage equality outside of the Supreme Court when the Obergefell decision was announced, and Obergefell basically declared that same-sex marriage was constitutional under the 14th Amendment. So this is not going to be in your textbook, so you do need to pay attention. Well, I say it's not. Some of this information is not going to be in your text, so pay attention. Some of it I added myself. So I am going to refer to the LGBTQ plus rights movement as the gay rights movement. It's the same thing. The gay rights movement arose throughout the 1960s because there were discriminatory laws in place that criminalized same-sex relationships and acts. And actually, there was a movement known as the Lavender Scare, in which governmental employees in the 1950s and 60s could be terminated from their employment if they were suspected to be homosexual, because it was thought that homosexuality was a weakness that the Russians could exploit to get governmental secrets. Throughout U.S. history, being homosexual has evolved. The thoughts behind it has evolved. It was originally thought of as a mental illness, a weakness that could be extorted. But the gay rights movement largely started with what was known as the Stonewall riots in 1969. That is largely seen as the start of the overall movement for equality. And with Stonewall riots, the Stonewall Inn was a gay bar, a homosexual bar, where people could go and build a sense of community, be themselves during the 60s, things like that. However, laws during that time were very restrictive, such as men could not dress in anything that resembled feminine attire. So you have transgendered citizens who would be arrested for violating that law. And so one night, the Stonewall Inn in 1969 was raided and shut down. People were arrested, and the patrons of Stonewall Inn basically said, "I've had enough," and started fighting back against law enforcement and against that law. Until the 1960s, all states criminalized same-sex sexual acts, and most prohibited appearing in public manner that was deemed as misaligned with the people's sex assigned at birth. These laws promoted extensive harassment by police, denial of rights, including veterans' rights, and acceptance of assault and discrimination against LGBTQ plus people. So we go through the 60s, 70s, 80s, 90s, with more and more conscious around the discrimination happening with this subset of population. A lot of state laws outlawed or banned sodomy. And sodomy was utilized, that law was utilized to outlaw same-sex sexual intimate partner relationships. It was until Lawrence v. Texas in 2003 that those laws were deemed unconstitutional. And basically, the Supreme Court in Lawrence v. Texas stated that states could not criminalize sexual intercourse between consenting same-sex couples. So that's the first big victory for LGBTQ rights and the gay rights movement. And then in 2015, you have Obergefell versus Hodges, because from 2000, before 2015, it was illegal. No state observed same-sex marriage. And it wasn't until Obergefell versus Hodges in 2015 that same-sex marriage was legalized in the in the court precedent. And we still operate under Obergefell. You are watching this in should be February 2023. I am recording this in December. We have just signed into law or codified same-sex marriage. Therefore, the Supreme Court, like it did in Plessy, cannot come back and overturn itself. Cannot come back and overturn Obergefell. And one reason why same-sex relationships was codified under the Respect for Marriage Act was because of the Dobbs decision. And so you see how the Dobbs decision kind of had a ripple effect. If you'll think back to what we just talked about, the Dobbs decision was the decision to overturn Roe v. Wade. So we didn't want another decision like that actually took away civil rights and civil liberties. So we codified it. Here are a couple of pictures. If you don't know, the first is the Obama White House. Whenever Obergefell was announced, the Obama White House lit up in the LGBTQ flag colors, which is the rainbow flag. And then the next picture again shows you the civil disobedience of the original Stonewall riots, and how people utilize their voice. All right, we have gone through a lot, through different people's, different groups' struggles to gain civil rights in this country. I hope that you all have enjoyed this journey. This will conclude Module 1, so the next thing that you will do will probably be your module exam. Good luck on that, and feel free to reach out to me, and we will come back and start talking about Module 2, which I deem politics, and in that module we'll really start delving into how ideology is formed, media influences the political parties and things like that. So good luck, and as always, feel free to reach out to me if you need anything. Thanks.